Welcome, everyone. Before we begin, I need to thank a few of our sponsors. First and foremost, the Department of Philosophy, without whose support there would be no one to facilitate these lectures. But also, we have a range of sponsors across campus that make this happen. So, I need to thank the Center for Animal Welfare Science, the Bindley Bioscience Center, the Brewer Chair of Applied Ethics, the Center for the Environment, the College of Health and Human Sciences, the Global Policy Research Center, the Graduate School, the College of Liberal Arts, the Purdue Policy Research Institute, the Department of Political Science, the College of Science, the College of Veterinary Medicine, and the Weldon School of Biomedical Engineering. So, our speaker today is Dr. Sandra Shapshay. She's the director of the Political and Civic Engagement Program, an affiliate faculty of the IU Center for Bioethics, and an associate professor of philosophy at IU Bloomington. The title of her talk today is Human Tissue Research, Consent and Justice, What the Case of Henrietta Lacks Can Still Teach Us Today. Please join me in welcoming our speaker. Thanks.
Thank you. Thank you so much for that lovely introduction, and it's really impressive that so many units on Purdue's campus can get together and sponsor an awesome lecture series like this one. But I want to also thank all the sponsors and thank the organizers, especially the philosophy department and Ryan Van Noot for really amazing logistical support. And I want to say also that when I told my undergraduate students that I was coming up to Purdue, being from IU, they said, "Oh, I can't believe you're going up to the enemy, right?" And I'm like, "Oh no, that's just, that rivalry, that's so overblown." But as I walked into the Purdue Union Hotel today, the first thing I saw on the desk there at the reception was a basket full of apples, and it said, "An apple a day keeps the Hoosiers away." And I was like, "Wow, nice." But luckily, yeah, on an academic level, there's obviously some wonderful collaboration between our IU and Purdue programs, and I want to also start off by saying that this paper is a work in progress. This is the first outing of this paper, and I'm really interested in hearing your feedback on it. Looking forward to the Q&A, and I'd love to be able to find its weaknesses as well as hopefully some strengths. So the title, as Ryan mentioned, is Human Tissue Research, Consent and Justice, What the Case of Henrietta Lacks Can Still Teach Us Today. Just a quick show of hands, how many of you have either read The Immortal Life of Henrietta Lacks or have seen the HBO film with Oprah Winfrey? Okay, quite a few people. Okay, yeah. All right, so okay, another question. How many of you have ever given a blood sample in a clinic? Okay, I think almost everybody. Okay, how about a blood or urine sample? Maybe that gets everybody. All right, okay. So this talk actually affects everybody in this room, because if you've given a blood sample, a urine sample, you've had any tissue taken whatsoever, this issue, whether you know or not, can potentially affect you. So, all right. So it's a vexed issue. And about 20 years ago, Georgetown law professor Larry Ghostin wrote that the legal and ethical issues about the use of stored tissue are probably the most profound, complex, and troubling of any ethical issue we have in science today. And given the success of the Human Genome Project and the rise of genomic medicine in the intervening years, Ghostin's statement seems all the more urgent today. So why this issue is so vexing is it pits two major values against each other. It pits the value of respect for individual autonomy against the concern for societal benefit and a reduction of suffering. So here we go. In 2010, Rebecca Skloot's best-selling book shone a bright light on the ethics of tissue research in the US today, and especially on the fact that federal regulations for research with human subjects seems to have a big ethical loophole in it. namely that no informed consent is required for the use of post-diagnostic or post-treatment tissues in scientific research. So the book, as those of you who have read it or those of you who have seen the HBO film know, the book reconstructs the case of Henrietta Lacks, a poor African-American woman who was the great-great-granddaughter of slaves who in the early 1950s received free care in the colored ward of Johns Hopkins Hospital. And she was the source for the first immortal cell line called HeLa. So little on HeLa here. So Henrietta Lacks was never asked for her consent to have her tumor biopsy utilized in research. And after her death, her family was never informed of the famous HeLa cell line that would become ubiquitous in laboratories around the world. And those of you in science majors have probably worked at some point with HeLa cells in the labs. The only time researchers actually interacted with her family was to get tissue samples from them, misleading them into thinking that they were receiving diagnosis for cancer. So the story is morally discomforting because it's a story of disrespect. It's the story of disregard for the autonomy of a poor African-American woman and that of her family by certain members of the scientific community. The case is not nearly as troubling as the notorious Tuskegee syphilis study that many of you are probably quite familiar with, in which several hundred African-American men were told that they were receiving treatment for syphilis, while in fact government researchers were just watching to see how the disease would progress. And this is even after the discovery that penicillin would cure syphilis. These men were not treated. So notwithstanding, there are big differences between the case of Henrietta Lacks and her family and the Tuskegee syphilis study. The harm, obviously, in the Tuskegee case was much greater. But one thing that you can certainly say is that in the Henrietta Lacks case, far too little concern was paid to her autonomy and that of her family. And one of the most shocking things that readers of Skloot's book have taken away is that still today, in 2010 when the book came out, and still today, not much has changed to protect patients from being unwillingly drafted into research via their tissue samples. Okay, so currently in the US, no consent is required to utilize a patient's post-diagnostic tissues in research. So if you go to a doctor and have a blood sample drawn, or you give a urine sample or any other kind of tissue sample, no consent is required for the clinician to store that sample and to utilize it in prospective downstream research, provided that your identity is removed from the sample. Okay. Further, there's no mandate to gain your consent in order for the clinician to sell or give away the de-identified sample to third parties who seek to utilize it in research. The two things that have changed, thank goodness, since from the case of Henrietta Lacks is that obviously there are no longer wards segregated by race in hospitals, and now the tissue samples must at least be de-identified such that they would no longer be named HeLa after the first two letters and the last two letters of Henrietta Lacks's name. But the Henrietta Lacks legacy culminated in 2015 in an attempt by the Department of Health and Human Services to change the regulations governing research with human subjects to mandate broad informed consent for all tissue research going forward. Okay. So that regulatory proposal met with vocal resistance from the scientific community, as well as from some bioethicists, and consequently it failed. And it actually failed quite recently, just in 2016. In this paper, I shall examine some of the arguments from scientists and bioethicists against mandating consent for post-diagnostic and therapeutic tissue research. So my aim in the paper is to argue that while these arguments from scientists and bioethicists have some merit in general, In the concrete situation of the United States today, there should be mandated informed consent for all future post-diagnostic tissue research. And in the process of trying to run this argument, I hope to highlight lingering lessons we have yet to fully appreciate from the case of Henrietta Lacks. Okay, so before making my positive case for consent for all prospective tissue research, it is helpful to sketch the landscape of this thorny debate just a little bit. So there are many facets to the stored tissue debate. And one case that is often cited is the case of John Moore, which may be familiar to you. And that's a case that, in cases where the tissues prove lucrative, right? And so then there are ethical and legal questions that arise about whether people should retain property rights in their discarded tissues or tissues they donate willingly for research purposes. So sometimes, albeit rarely, the tissues become the source of commercially advantageous patents and profitable biotechnologies. And there's a question of whether the human being who is the source of those tissues is owed some kind of compensation for them or some share in the profits. So this is a fascinating issue, but I'm going to leave this one on the side. And it's actually it's a hotter issue for lawyers. I'm going to focus instead on the issue of whether in a clinical setting patients should have to be asked for their express written consent to have their tissue, have their biospecimens utilized in research. Okay, so in 1997, the NBAC, the National Bioethics Advisory Council, that was under President Clinton at the time, decided to take up the issue of the ethics of research with human tissue samples. And as part of that report, Eisenman and Haga undertook a national inventory of stored biospecimens. And in 1999, they published an inventory which estimated at the time that there were approximately 307 million tissue specimens stored in the United States alone. And those specimens were stored by the military, in academic medical centers, tumor registries, departments of forensic sciences, blood banks, sperm, ovum, and embryo banks, all kinds of places. Most of those tissues stored were from diagnostic or therapeutic purposes, from a clinical setting. And they estimated that about 20 million new samples were stored every year. So assuming conservatively that the rate of tissue storage has remained relatively constant, and assuming not as conservatively that the extant tissue samples in 1999 are still in storage, that means that today there are approximately 667 million stored tissue samples in the US today, about 2 samples for every citizen of the United States. So a lot of samples, quite a lot of samples out there. So as I'll discuss a little bit further, scientists tend to favor the regulatory status quo here, because obviously it affords very easy access to a wide array of biospecimens that are vital to conducting socially beneficial research. And they worry that mandating informed consent going forward will be burdensome, costly, and will limit the number of biospecimens they can use, and will slow down the pace of important research. But the main worry about not requiring informed consent for post-diagnostic tissue research is that it is generally a standard ethical requirement in research with human subjects that those subjects give their express informed consent to participate. So, and that standard requirement is based on the principle of respect for individual autonomy. And I'm sure, as most of you know, the respect for individual autonomy is a major principle in contemporary bioethics, including research ethics. And the thought here is that competent individuals should always be free to make an informed choice on whether or not their bodies are to be utilized in scientific research. But in the current regulatory landscape, most people really have no idea what happens to their tissue discards. And since most people are not told what a reasonable person would want to know about what is happening to their to their tissues, they clearly cannot make an informed choice. And in most cases, there is no choice to be made because they are simply used in a de-identified form. Okay, so furthermore, in a study done by Weir and colleagues of 93 adult outpatients in a family medicine clinic in Iowa City, about 75% of people surveyed said that they would be either very bothered or somewhat bothered to if research were done on their tissues without their consent. And many other surveys cited then by the Health and Human Services Department had the same kind of result, that the majority of people said, at least those who were surveyed, wanted to be at least asked for their consent to have their tissues used. But I think even if only a quarter of the people were bothered, or even none were bothered, I think people can be wronged by having their autonomy disrespected, even if they don't realize they've been disrespected, and even if they don't care. Because disrespect is disrespect whether or not people are bothered by it. But the second main reason for mandating informed consent is to help protect research participants from being harmed by their participation in research studies. And it's the case that any nucleated cell in your body contains your DNA. And genomic medicine has advanced to the point that a genetic test at this point can tell whether you are going to develop the symptoms of Huntington's disease, or it can yield probabilistic evidence on your chance of having Alzheimer's or Parkinson's disease, or breast cancer, or other cancers. So people are understandably fearful that their genetic information may become public and used in a kind of Gattaca-like way, especially in a highly privatized and competitive society like the United States, to deny them health insurance, coverage, or employment. And furthermore, genetic information is such that your biological family member's privacy is also put at risk by a person participating in tissue research if your genome should become public or disclosed to third parties. So notwithstanding the 2008 Genetic Information Non-Discrimination Act, GINA, that prohibits health insurers and employers from discriminating on the basis of genetic information, there's still the worry that such a law constitutes a last legal resort for people after the discrimination has already happened. Also, the law does not cover life insurance companies or long-term care and disability insurance. So in the United States, patients and even their family members may be harmed in a serious way by their participation in tissue research should their genetic information be disclosed or be disclosed to third parties or be made public. So the requirement of informed consent is a mechanism for encouraging researchers to take pains to protect the privacy of a person's genetic information and to disclose to patients the measures they will take to do so, lest the potential subject decides to opt out. Thus, the requirement of express written consent is a curb to research risk. There's one last reason I just threw in to round out the case for consent. There are other reasons, but I think this one is also potent, which is that mandating consent will promote trust, the public's trust in research, which is a recurring theme actually in Henrietta Lacks' stories, that Henrietta Lacks' family, they're all extremely distrustful of Hopkins and the research enterprise in general, and this is a very widespread belief, widespread distrust, especially in the African American community in the United States. So my pro-consent argument is not a very original argument. This is not the original part of the paper, so just a little disclaimer. It has been eloquently made by several bioethicists and scientists, Kathy Hudson and Francis Collins among them, writing in the New England Journal of Medicine in support of the regulations before they unfortunately failed to pass, or at least that regulation part. So as I alluded to at the start of the paper, the personal story of Henrietta Lacks, as told in Skloot's book, actually triggered this attempt at broad policy change in 2015. So And underscoring the urgency to address this issue, in 2013, researchers from the European Molecular Biology Laboratory published an article containing the genome sequence of the HeLa cell line. And following the standard practice, posted the entire sequence online as a resource for other researchers. So although the cell line had mutated quite a bit in the 60 years in which it had been in use, nonetheless, the sequence would provide probabilistic information not only on Henrietta Lacks, who is deceased for a while, but also her family members, who at this point were extremely well known to the public by virtue of Skloot's book, and thus compromising their genetic privacy. So consequently, Skloot and the members of the Lacks family raised concerns with the researchers who, as a result, removed the sequence from the internet. But making privacy matters worse, a number of recent studies have shown that even de-identified genomic information can never truly be anonymized. So in 2013, researchers at the Whitehead Institute, affiliated with MIT, were able to track down the identities of 50 individuals who had participated in genomic studies. And this is a direct quote from the researcher, the lead researcher. He said, he was able to track down 50 individuals who had participated, quote, using only a computer, an internet connection, and publicly accessible online resources. Even when their genetic information was held in databases in de-identified form. So Whitehead fellow Janif Ehrlich, who led the study, wrote that, quote, this is an important result that points out the potential for breaches of privacy in genomic studies. And so reflecting on the new reality that no tissue seems to be truly anonymizable, Henry Greeley and Mildred Cho warned that the same fate that befell the Lacks family, having the whole genome posted publicly online, could befall many, many more people. And they write, a bigger issue is the many other human samples and data sets that are broadly accessible to researchers and sometimes the public. Some come with no consent, some have some consent, but few have actual and honest informed consent to be used for any purpose by any researchers or for data to be publicly available online. And although most are stripped of any individual identifiers, that is cold comfort in an era of common breaches of data confidentiality and the use of other data sets to re-identify anonymized data and samples. Okay. So thus the HHS proposed rule change. Okay, and it's worth noting actually that the Health and Human Services rules, known as the Common Rule governing research with human subjects, had not actually been changed in any significant way since 1981 when they were adopted. This is a long time ago. And they were put into, that common rule put into concrete policy the Belmont Report from 1979, which lay out the principles of research ethics with, and that the Belmont Report itself was a response in large part to the Tuskegee syphilis study. So it had been a long time since something sort of shook up the regulatory world, and the regulations were changed or attempted to be changed. Okay. All right. So so in addition to concerns about genetic privacy, the Health and Human Services cited the public's greater desire to play a participatory role in clinical medicine and research, the desire to be asked for their permission. And then once the HHS put the new proposed regulations out there, they allowed for a lengthy comment period. And you can read the 2,000 plus comments. I've read most of them at this point on the Federal Register. And many of the comments are really quite interesting, the ones from ordinary citizens. And I found it really impressive that ordinary citizens actually found out how to comment, because it's actually kind of difficult to navigate that site. So I'm very impressed that some ordinary citizens went on and left comments like this from Anthony Proth, who writes, "The government should require anyone looking to use someone's body or cells to get consent. They should also be required to inform the individual of the who, what, how, and why they want to use them. No one or their family should have to go through what the Lacks family been going through. And there's some really, I won't go through all of these, but I'll make the slides available through Ryan. So if you want to check out, I just sampled some of the really interesting comments that members of the public left on the site. And here's another one, but in the interest of not boring you guys too much, I'm gonna try to pick up my pace here. All right, so the scientists push back though. One of the main, most important voices opposed to the proposed rule change mandating consent, and cited by many of the other commenters on the Federal Register, was the National Academies of Sciences, Engineering, and Medicine report called Optimizing the Nation's Investment in Academic Research, a New Regulatory Framework for the 21st Century. And their main argument was that requiring consent for all research involving biospecimens, as contemplated by the Advance Notice of Proposed Rulemaking, would substantially increase the administrative burdens on investigators, research staff, and institutions, and would markedly hinder the conduct of critical science. So one of the commenters on the site fleshed this view out quite clearly. Is Brian Grimberg, an assistant professor of international health, infectious disease, and immunology at Case Western Reserve. And he basically summarized the main points of most of the scientists who pushed back on this, that the consent requirement and the mandate to not just have patients consent or not consent to having their tissues used in this way, but also to have to track that consent because consent, according to research ethics, is something that should always be able to be revoked. So you really need to track it so that if somebody says, no, I don't want this anymore, you would be able to take that sample or the data out of the study. So that he thought that the consent requirement would overwhelm hospitals, clinics, and offices, and that the clinics would simply then discard the samples. You know, it would be too much trouble. So another thing, obviously, the cost of using biospecimens in research would go up. The NPRM estimated about $1 billion per year, and Grimberg actually thinks that was a low estimate, that billions of dollars would no longer be available for conducting research. And then the last reason, which I'll quote in full because it's really important. He says, while not increasing the protection of human subjects, which we all agree is important, the proposed rule changes will slow research, slow medical diagnosis, and kill people because of significant and unnecessary delays it will impose on discovery. So that is, I mean, most of the scientists arguing against the rule change pretty much use those kinds of arguments. But in addition, to try to sort of tip the scale, there were also some bioethical arguments against consent. Oh, but actually, before I get into that, I'm sorry. Let me just say a few words about these concerns. So I would agree that actually these are valid concerns. The new regulation would have increased burdens in clinical settings. It would cost researchers quite a bit of money. However, the proposed rules were also only going to be applicable to new biospecimens, not all the ones stored in the past. It had a phase-in period of 3 years, so that, you know, that at the beginning it would have been a cumbersome and difficult process, but then it would have been, you know, the consent process would have probably been worked out after the 3 years' time, and would become routine and less costly. The other thing, actually, that a number of scientists argued is that, well, if people were asked for their consent, then they won't give their consent, you know? But actually, you might be surprised that I think a lot of people maybe would, because has anyone been on the 23andMe site? 23andMe, the direct-to-consumer genetic testing site? So I was surprised to learn, tooling around on that site, that so they make it an option for you to allow your sample, your spit sample, to be used in research. And and they have a very nice consent form that explains the measures they'll use to try to protect your genetic privacy, when they will give your sample to researchers, under what conditions, that law enforcement will be able to like, check out your sample if there's a subpoena. So they have this robust, pretty robust consent form, and a place where you can always revoke it, although it takes 30 days to get it, to get that processed. But 80% of people actually consent to have their sample used in research, notwithstanding, all of the kind of caveats. So it seems that, that it's likely that a lot of people would still consent to having their sample used. Okay. But I would also say, especially to the point 3, that if you really think the protection of human subjects is important, both in terms of protecting them from risk and respecting their autonomy, you would take more seriously people's concerns for their genetic privacy. But there are also bioethical arguments, so against the consent, and excuse me, and these are arguments that underscore a duty of beneficence and the value of social solidarity as a counter to the emphasis on respect for individual autonomy. Okay, so so for example, Bartha Maria Knoppers and Ruth Chadwick identify and support, these new trends in ethics that emphasize reciprocity, mutuality, solidarity, and seek to move away from autonomy as the ultimate arbiter. So they write, it's not at all obvious why a right to refuse to participate in genetic research when it could be to the benefit of others should be overriding. And also, Eric Christensen argued that when the degree of risk is so low and the potential gain for society so great, it is justified or legitimate to ask whether the right of self-determination and the requirement of informed consent should carry as much weight in biobank research compared to other forms of medical research where the risk to the individual is considerably greater. So he argues that there's a kind of exceptionalism to biobank research. It's not as risky as other sorts to human subjects, so that's one place where you can waive the whole requirement for informed consent. But perhaps the most pithy way of putting these kind of solidaristic arguments comes from David Korn, Vice Provost for Research at Harvard, who writes that, quote, people are morally obligated to allow their bits and pieces to be used to advance knowledge to help others. Since everybody benefits, everyone can accept the small risks of having their tissue scraps used in research. Okay. So this sort of sums up that bioethical case against consent to all tissue research. And I think there are significant problems, however, for deploying these arguments against mandating informed consent, and especially, I'll argue, in the United States in particular. So starting with the last formulation, the Korn formulation, which is the most pithy. With respect to the United States, strictly speaking, both parts of that statement, that people should accept the small risks because everyone benefits, both of those are based on false assumptions and are false. So attention to the story of the immortal life of Henrietta Lacks actually reveals them to be false. Skloot's narrative importantly provides a wider historical and socio-political as well as personal context that casts a lot of light onto these ethical issues. And this is where the story still, I think, has lessons to afford us. So in a very poignant episode of the book, Deborah, who's Henrietta's daughter, reflects on the scientific legacy of her mother's cells. And she says, truth be told, I can't get mad at science because it helps people live. And I'd be messed without it. I'm a walking drugstore. If you saw the film, like they show all the pills that she does take. But I won't lie, I would like some health insurance. So I don't got to pay all that money every month for drugs my mother's cells probably helped make. Also, Lawrence Lacks, Henrietta's son, is quoted in the book as saying, Hopkins say they gave themselves away, but they made millions. It's not fair. Her family is living in poverty. If our mother is so important to science, why can't we get health insurance? Okay, so in a highly privatized healthcare system like the one that we have in the United States, even with the Affordable Care Act, which, as y'all know, came very close to being repealed in the last few months, it's actually just false that everyone benefits from medical advances based on tissue research. Okay, the approximately 32 million people who still do not have access to health insurance and who consequently have to rely on emergency room care or have to make trade-offs between essential needs, other essential needs to pay for their, to see a doctor or to pay for a prescription, and risk bankruptcy if they do seek medical care. Those folks cannot be said to have a decent minimum access to health care. And given the lack of health insurance, people like Deborah cannot be truly said to benefit from advances spurred by tissue research. And even if they benefit somewhat through visiting the doctor occasionally, potentially bankrupting themselves, they do not benefit at all equally to people like Dr. Korn from Harvard, or likely most of us in this room who are employed by universities and have great access to health care, and thus great access to the benefits of tissue research. Okay, so the arguments that appeal to social solidarity and supporting the common good may carry a lot of weight in countries like Norway, and it's probably not a coincidence that Christians and many of the folks other than Korn, actually, whom I quoted before, are from Norway and the United Kingdom and Canada, and places like Germany, where all citizens are guaranteed by the government a decent minimum of health care access, and access that is reliable. But in the United States, these arguments should ring hollow because of serious inequalities in healthcare access in our country. Okay. Another lesson I think we should take away from the story of Henrietta Lacks and her family is the focus on race and the legacy of institutional racism, and that legacy, the legacy that has left on healthcare access and inequalities. So, for example, this slide from the Kaiser Family Foundation highlights large gaps in coverage, still even with the Affordable Care Act in place today, although it's being kind of chipped away at. So we see in Skloot's book that Henrietta Lacks' poverty is in no small measure the result of the injustice of slavery and the injustice of Jim Crow segregation and subjugation of African Americans. And further, the lack of any reparations made for these institutional injustices. So Henrietta Lacks was, as I said at the start of the talk, the great-great-granddaughter of slaves in Clover, Virginia. She actually grew up in a log cabin that was literally the slave quarters of her family. So it's not surprising that she had to rely on both a racially segregated clinic as well as the free care ward at Johns Hopkins Hospital. And it's not surprising that her family would struggle to have access to health care either. So because of the Affordable Care Act in 2010, that went into effect in 2014, about 22 million people, Americans, have gained health insurance coverage. But according to the nonpartisan Kaiser Family Foundation, 32 million Americans still lack health insurance coverage. And about 2/3 of the people who lack coverage, who are in this sort of white zone in the middle of the umbrella there, about 2/3 of those people are ethnic and racial minorities. And they're uninsured because, in large part, of the 19 states, mostly in the South, that refused to partake in the Medicaid expansion program of the ACA. So it was left up to the states to decide if they would participate in the Medicaid expansion, and and a bunch of states did not. So you see today that poverty in general, but also racial disparities in income and wealth make it such that not everybody benefits from tissue research. Korn ignores the factor of real wealth and income inequalities, many of which stem from the long history of institutional racism in this country. So what about the other statement, Korn's statement, going back just a couple of slides here. So he writes, so since everyone benefits, everyone can accept the small risks of having their tissue scraps used in research. Okay, the small risks. So I think Korn, Christensen, Berg, Knoppers, Chadwick, they all downplay the issue of risk, seeing the risk of participation in biobank research as quite small. So it's reasonable for them to hold that the duty of beneficence should outweigh the concern for autonomy and the concern for the risk. To be fair to all of those thinkers, okay, they were all writing before 2013. And 2013 is when both Henrietta Lacks's genome was posted publicly online, and it was also the year that Yaniv Ehrlich came out with this study that showed he could de-identify all these genetic samples. So to be fair, they might have downplayed the risks because maybe at that point the risks weren't so great. But it seems that now the potential for the loss of genetic privacy is quite a significant risk. It's at least more than minimal risk. And it's a fundamental principle of research ethics, enshrined as far back as the Nuremberg Code in 1949, that the voluntary informed consent of research subjects is absolutely essential, especially when there is more than minimal risk involved. So that should I think make us reconsider the whole risk-benefit calculus that most of those thinkers thought were, clearly the risk was extremely small. So I am almost done here. I'm just going to sum up. So to sum up, the arguments against consent for tissue research from scientists and bioethicists have some merit. I'm not saying that they don't have merit, but they have more merit in countries like Norway and the United Kingdom and Canada, where there is much greater social solidarity around access to health care. But when seen in the light of the history and the concrete healthcare access situation in the United States today, in the US, I think there should be mandated informed consent for all tissue research going forward. Unfortunately, for better or for worse, the story of Henrietta Lacks is a very American story. It's both an inspiring story and it's a really horrible story. We have a story of tremendous scientific breakthroughs and the story of racially tinged disrespect for research subjects. It's also the story, as you see through her children, Deborah and Lawrence, it's a story of very unequal access to healthcare and very precarious access, highlighting what I think are more than minimal risks of the loss of genetic privacy. Because in a country where people rely on an employer or they rely on a healthcare market, if folks start utilizing publicly accessible genetic information to discriminate in their employment in healthcare or long-term disability, et cetera, kinds of coverage, then that is a fairly potent risk. So in sum, when our healthcare system is as equitable as Norway's, then and only then we should revisit the aforementioned solidarity-based arguments. And in an era of genomic medicine where no one's DNA sample is truly anonymizable, the risks to the subjects of tissue research is more than minimal. Therefore, respect for persons requires informed consent, even if this will be somewhat burdensome and costly to scientists. And so my bottom line is, unfortunately, sometimes doing the right thing costs money and time. Thank you very much. Yeah.
Thank you so much. So the deal with the microphone is that you have to flip it up, ask your question, and then
I am a professor in human development and family studies. I do genetics research. I think about these problems all the time. And I would love to hear your thoughts on informed consent for genetics research. Considering the Henrietta Lacks case, her family is affected right now. But even if Henrietta Lacks was asked consent and gave it, her family would still be affected. So do you have to then get consent from all of my immediate family members and all of my children and their children, and how do you figure out where that line is?
That's a really great question, and it's true. You might think, well, you should be getting the consent of all the people whose genetic privacy might be compromised. That would be really hard. So yeah, I think there's a valid case to be made for doing just that. It would probably become so difficult to get research subjects that it would be extraordinarily cumbersome. So I think in some kind of compromise, because this issue really is one of kind of a balance, right, of respecting individual autonomy and individuals who are also compromised by the one research subject's autonomy, and social, and the promise of societal benefit from this important research. So I mean, I would think that, I guess I would come down on perhaps to balance things, to make it less, not impossible for scientists to continue to do this research, ask for the individual consent, but impose tremendous kind of protocol to protect genetic privacy. And I think I'm hopeful that the more people understand the risks that are out there, which seem to, have only been really clear risks since about 2013. So it's not a long time ago, but the more people understand the risks, the more they will want to see, they will want to be asked for their consent and will want to get a lot of things very clearly demarcated in the consent form before they opt in.
You said that scientists would end up having, and researchers would end up having to pay more money for this. If it becomes law, is it not the government that's paying to monitor and regulate all of this information that's being stored, and also maintain the security that's upkept on the actual data itself? Because the cost of data storage is not insignificant. It can get very large, especially when you're trying to secure it. So I guess my question is, wouldn't this end up boiling back down on the taxpayers? And then the individual argument for me becomes, I'm paying more money to potentially dent the research and development of medical things that could benefit me or others around me.
Yeah, so the proposed regulations would simply regulate, so that not pay for the added, burdensome consent process or the data storage or the tracking. Just so they would be proposed just like part of the common rule that governs research with human subjects in any study that has federal funding whatsoever. So it would go to an IRB or institutional review board at a university, or there are different sorts of IRBs, but so it would basically be put back on the researcher to pay for the process. It wouldn't actually wouldn't directly come out of taxpayer money. However, you're right to think, well, eventually it will, because a lot of the researchers rely on government funding, right? Federally funded research. So if their costs are, the research dollars then they're getting from grants, more of those dollars would need to be put toward toward gaining the consent, tracking the storage, and all that. So ultimately, yeah, it would. You're right that it would put a strain on federal funding, at least through the research pipeline. That, perhaps the grant money wouldn't go as far, right? So I think you're pointing out that maybe there's a taxpayer argument. Well, like, gosh, it seems like it's a good idea to have more protections, but it's ultimately going to cost us all more, and so that might be another reason to think, well, maybe I don't want to go for that. Maybe the risk, and I'll do the risk-benefit calculus, and I'm going to come out saying, no, we shouldn't do the consent thing for all tissue research. But my argument against that would still be, well, sometimes you do have to pay. You have to pay some money. You have to perhaps slow things down to some extent in order to respect people, so that ethics can be somewhat costly. Like having decent ethics in your research can be costly. And if you look at like the notorious Tuskegee syphilis experiment, you might say, well, certainly it was the best way the most cost-effective way to figure out the disease process of syphilis, but is completely unethical, right? So sometimes, the most cost-effective way, the way that would be cheaper to taxpayers, we shouldn't go that route because of the disrespect that it involves, the abuse or the disrespect of research subjects.
Less subtly than that question, I'm wondering about the economics with the sense of, is there a reparations aspect to this ethical argument? Because there are tremendous externalized costs in biomedical research, especially since the 1980 Bayh-Dole Act, which would allow any publicly funded research to then be privatized for the benefit mostly of institutions like universities or private companies. So if we are considering the consent of those individuals and trying to build an equitable system wherein the benefits would flow back to said individuals, doesn't that imply reparations?
Yeah, and I think, well, I think you're getting at a sort of a kind of a strange thing that I started to realize about my own paper as I was writing it, which was, in some ways, in some ways, I think the main thing that I care about is equitable access to health care. And in some ways, if we had that in this country, I think maybe those solidarity arguments would be effective. Maybe they would actually be effective enough to overcome the, provided the risks could be managed and would be managed maybe by additional legislation to make sure, like to toughen up genetic privacy, then maybe I would do the calculus the other way and say, okay, forget consent for tissue research, as long as we all have really, everybody gets a decent minimum access to health care. So in some ways, I guess as actual solidarity increases, which you might see as part of a reparation, and I think you can make a very good case that at least certain people in our society are owed health care as a reparation. African Americans, Native Americans, perhaps disabled veterans. I mean, these folks have a claim to health care, to either for reparations for past injustices or maybe extraordinary service. So yeah, I think that's kind of a weird thing I was realizing about my argument, is that it could, it's sort of place-based. It's very much society-based. Like, if we're in Norway, okay, we could work it out in another way, but we're here, and as long as we have the conditions that we have on the ground, I would want to work it out in favor of consent. And did I answer the question? Yeah. Are you sure? Okay, all right.
So thank
you for your talk, Sandy. I really enjoyed it. And I think my question is sort of related to these two, but maybe from a different angle. And it's sort of a half-baked question and more about a curiosity, and wondering sort of what you think and if anybody takes this tact, which is not the backwards-looking reparations angle, but the sort of stronger forward-looking angle of, are there people who argue that we shouldn't just be seeking consent, but compensation for giving ourselves for research? The idea that, right, if we're going to say that this is part of sort of my autonomous human being, then this is something that if I'm going to give it up, maybe I shouldn't have to give it up for free, and maybe I should be compensated for it. And so I'm wondering, one, just generally what you think about that sort of stronger version of this, and two, if anybody takes that sort of tact in making these types of arguments that we shouldn't just look for consent, but like draft business contracts whenever we're doing this, so that not only am I getting paid some small amount for the cells that you're taking, but also will be paid if this turns into some groundbreaking research or something like this.
Yeah, that's a good question. That's a case. That's an issue that was brought up very prominently by this case of John Moore, which went to the California Supreme Court, and the California Supreme Court ruled that Moore had gone for treatment for hairy cell leukemia. The doctor who was treating him at UCLA found that his spleen had these like crazy leukocytes in them and saw a commercial possibility there. Didn't tell him that he was going to use his cells at all for research. Patented it, made a killing off of it. Finally, Moore realized, like, hey, wait a minute, I keep getting called down for more tissue samples, and I'm flying down, and he got sort of wind that maybe he was being used. So he sued. He found out he was being used in research, sued, and he sued on two grounds. First, that he had not been informed that he was being drafted into research, and on that he was successful. The California Supreme Court agreed that, yeah, the doctor had not, performed his fiduciary duty and had not properly informed him of this. But then he also sued that he was owed some profits because he had property rights in those cells. And the Supreme Court, California, it's a pretty controversial case. The California Supreme Court said, no, you don't have property rights in your discarded tissues, and that since the physician and his colleague, Shirley Kwan, since they had to do a lot to his cells to make them marketable, then it was found that, well, he had no sort of legal leg to stand on there, and Moore actually tried to get the Supreme Court in 2001 to take up that case, but they wouldn't look at it, and so I think it's still a very controversial issue, whether you should, and I think honestly, I haven't made up my mind on this one yet. So whether you really should have property rights in your cells, that raises some thorny ontological questions, because is that you anymore? It's definitely your genetic code, but does that make it you? Is it really yours? I guess at this point I'm sort of leaning toward no. But I think so. So I think the consent issue would, in some ways, give the patient some power here and autonomy. So if you might consent to having your tissues used in research, but only consent if maybe you would share the profits, et cetera, et cetera. So there could be, you might consent, but if you really feel strongly like I should have the profits, that could be part of what you're opting into, or you would choose to opt out of. So I think that's, but honestly, I haven't thought enough about the ontology there in the cells. But it's a very tricky case. Yeah.
We have time for one or two more questions.
let's grant that we have a terrible history of racism, and that includes in scientific and medical research. And let's grant that we have an incredibly inequitable system of access to medical care in the United States. I don't think either of those are actually relevant to the larger issues that you're addressing. So you've tried to make the equation of autonomy to my organs being something that I control once they're out of me. I'm not sure that there's any philosophical basis for maintaining that, and the other things are sort of irrelevant to that argument. To go back to the question here, say I have an identical twin, and I not only consent to my tissues being used in research, but I consent to my sequences being public information. Does the other person have to be consulted? And on and on, about that. The final thing is, if I really wanted the sequence of anybody in this room, it would be pretty easy for me to obtain it. So I'm not sure what we're gaining by preventing people's discarded tissues from being used. People, as you said, the people are doing this 23andMe. Anybody who thinks that databases are secure is definitely fooling themselves. And so we have a large population that's already, out there, and they're not willingly consenting to their DNA sequence being public. But it is public because it's going to be compromised. I mean, that's what happens with databases. So I'm trying to understand, given all those problems, why informed consent? And the final thing is, informed consent isn't really all it's cracked up to be. Most ethicists nowadays really don't think that informed consent is all that effective. I'm not opposed to informed consent. I'm not opposed to, again, when you're actually participating as a human being in a research program of having informed consent. But it seems a bit remote to think that that's necessary for tissues.
Yeah, no, I think these are good concerns. I think one thing that actually didn't put in the paper that I think might strengthen the case for consent, especially in a healthcare, consent to have your tissue discards used in research, especially in a clinical setting, is that you do consent for the clinical part of it, right? You need to be asked, can we take your blood for this particular purpose? And there are HIPAA protections for your medical information in that context. I actually think in some ways in the clinical setting, even though I agree that the worries that Max raised about, the ontology, are these cells still mine, there's part of my body, in the clinical setting, there's almost a kind of bait and switch going on, because you go in there and you are consenting to have a particular procedure done. You should at least think you've got these HIPAA protections on the privacy of your health information, but lo and behold, one of the most, maybe vital bits of information, your genome sequence, is not at all protected in that setting. So there's in some ways, I think in some ways the consent, regardless of the ontological issues, is needed in order for that clinical encounter not to become highly misleading. Because I think when you go into the clinical setting, you have certain legitimate, in this country, you have legitimate expectations that your medical information will be private and will only be disclosed under certain conditions. So I think that could strengthen the whole consent thing. On the 23andMe site, I do think in some ways it's crazy that 80% of people consent to having their DNA, their sample be made available for research, although there is a place where you can always revoke it, because actually yeah, I think you're right, databases are, nowadays we know they get hacked all the time, and unless you're just wanting to put it out there, it's probably a pretty, it seems to me a risky thing to do. But I think you're right that I still have some work to do to show that that the risks of real harm to people are real. That if someone, I guess the risk of companies or employers trying to use the information, either if it's made public or there's a data breach of some sort, in actual, kind of actuarial decisions. And I think in some ways, maybe we'll only know once companies really start doing this, if that's how potent that risk is. I think I probably didn't answer one part of your question. I'm sorry.
Alrighty.
Any other?
Okay, we have time for one more question. You put your hands back down. What would you like to do?
Okay, it's still on. So I have a short question and then a normal size question. But the short one is there any other data besides this 23andMe that you're citing where 80% of people consented that, is a more representative sample? Because obviously if someone is going to that site, then they have a certain, amount of interest and belief in, in genetics and things like that. And my second question is, do you think that, a lot of the uncertainties that have been brought up in these questions, such as in terms of compensation, in terms of cost, in terms of, even the significance of, do we own our organs? Do you think that those uncertainties are contributing to the fact that there has not been regulations put in place yet for this? Do those kinks need to be worked out before anything could successfully be implemented?
Oh, okay. So do I have any more evidence that people would still kind of volunteer for this? No, and I actually should. There are a bunch of other ancestry sites that I should study and see. Okay, what percentage of those folks? Although that you're right, it's a sort of self-selecting group. But actually, to return to this gentleman's question, though, in some ways, the way consent. You're right that the way consent is often treated in clinical and other settings is that it's just this sort of pro forma thing, and you kind of rush through it, and it's like, it's a long form, nobody's going to read it. And so, in some ways, that does promote people consenting, although I actually think that's terrible because it undermines the whole informed part of things. So, I guess it's hard to say whether you'd still get the same percentage of people opting in if they really were well informed in a general way. And I guess sort of I would want the chips to fall where they may, because ultimately I think people should know and should be informed and make a decision. And if it's the case that people are feeling really worried about their genetic privacy, that we're not getting the same numbers as the 23andMe site, well, that means that maybe the researchers have to work a bit harder to safeguard or to show that that they're going to try to protect it. So so you said the regulations. Would you repeat just the last part of the question?
Yeah, just a lot of the questions today have brought up uncertainties or kind of things that still need to be worked out as to how it would actually work in practice to require informed consent for all tissues and genetics, et cetera.
Yeah.
So do you think that those uncertainties are why the regulation
That was
must go?
that's a really good question. So in part that was also cited by scientists, and even some bioethicists were saying, hey, maybe you guys should give us a little more like flesh on the bone here. How is this all going to work? And some bioethicists actually were unhappy with the broad consent and how that would be operationalized because, is it really consent if you're just like consenting to who knows what? And even one kind of major proponent of informed consent for tissue research, Ellen Clayton, kind of didn't support the regs for the reason of the broad consent was too broad, that it wasn't, that broad consent couldn't be really truly informed consent. So yeah, I think that's in part why some people decided they weren't going to support the regs or they were going to argue against them because of the kind of the how exactly is this going to be worked out.
So do you think that it should be implemented and then kind of figured out, or do you have a plan for exactly how to implement it?
I actually don't. I don't think. Well, my concern was mostly to argue that there should be, right? And in some ways, I'm leaving the how to other people who are sort of have a better understanding of data storage and other things. But I actually don't think in principle that it would be so hard to add a not very difficult consent form to the clinical encounter. Right now, if you have your blood drawn in a clinic, you have the form anyway that you're going to sign. So it could be like, okay, here's your consent form for the clinical part of it, and here at the bottom there's this other part. Okay, do you consent to having your tissue then utilized in research, and it would be utilized in this way, it would be de-identified in this way, and it would be protected in this way? Yes or no? Like that strikes me as if you fold sort of the two consent things. I mean, obviously keeping them separate, but you could kind of make them part of a consent process. And there are folks who work on trying to make consent a better process by utilizing videos and and other kinds of friendlier technologies that kind of walk a person through the issues. But I mean, no matter how you slice it, it would certainly add another layer to the encounter and slow things down a bit. But I think it would be worth it to do so from an ethical point of view.
Okay, let's thank Dr. Shapshay.